Welcome to Illinois Harassment Prevention Training. This training meets Illinois Human Rights Act IHRA requirements for annual mandatory workplace prevention. Effective January 1st, 2020, all Illinois employers are required to provide annual sexual harassment training to all employees covering specific topics that we are going to review today. So by the end of this presentation, you will know what unlawful harassment is, you'll understand employer and employee responsibilities, and understand the complaint reporting procedures and the concepts of no retaliation. So, we recently made a video on California harassment prevention training because different states have different compliance requirements. And you can see from this slide the differences between California and Illinois. Today, we are covering the state of Illinois, obviously. But if you're interested in harassment prevention training for California, check out that video that's linked in the description box. The content of this video is for informational purposes only. It is not intended as legal advice. Laws and legal requirements regarding harassment prevention can vary by jurisdiction. So this means you should verify the specific legal requirements that apply to you, to your state, and consult with a qualified attorney if you have any questions or need specific guidance. And just so you know, liking and subscribing is appreciated. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. Okay, so did you know that more than 60% of people, 60% of employees who face harassment at work never even bother to report it? That's a staggering number considering the millions of workers that exist in the US. And what's even more staggering is even when someone does speak up, they don't see any real change or justice. Well, guys, this creates an additional barrier to harassment prevention. How can you prevent harassment if those people who are speaking up about it don't see the benefit of speaking up? Today, we are talking about how to recognize these behaviors, the right way to report them, and how we can work together to prevent misconduct at work, because everyone deserves a safe and respectful work environment. This training includes real-world examples, legal definitions, and interactive features, so stay engaged and be ready to test your knowledge at the end with a quiz. All right, let's get started with this workplace harassment prevention training for Illinois. Harassment, discrimination, and retaliation have no business in our businesses. They are, without question, completely unacceptable. Over the last couple of years, most workplaces have adopted a zero-tolerance sexual harassment policy. What used to be perceived by some as okay isn't anymore, and likely never was. Allegations of sexual harassment or assault of a colleague, a supervisor, client, or even a business contact can lead to the accused employee's termination of employment. And employees are now feeling more empowered than ever, and that's a good thing. But some, unfortunately, will take advantage of the changes in the workplace, which is another reason why it's so important to take allegations of workplace harassment seriously. The Illinois Human Rights Act, IHRA, prohibits sexual harassment in employment, and it is a civil rights violation for any employer, employee, agent of any employer, employment agency, or labor organization to engage in sexual harassment. The Civil Rights Act of 1964, which is also known as Title VII, also prohibits sexual harassment. The IHRA defines sexual harassment as any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, and submission to or rejection of that conduct by an employee is used as the basis for employment decisions affecting that employee, or the conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. Okay, so now that we've reviewed the definition, let's turn our attention to what it means. What does this definition mean in practical terms, and how it applies to employers and employees in their day to day work? There are two types of sexual harassment: quid pro quo and hostile work environment. Quid pro quo is a Latin term that means this for that. And sexual harassment occurs when someone, typically a manager or supervisor, someone with control and authority over another person, makes unwelcome sexual advances or makes requests for sexual favors. And going along with this behavior is either required to get or retain the job, or it influences promotions and other work decisions that affect the person. If you want to know more about workplace harassment laws and how they have developed over time and why standing up against harassment is so important, you have to check out my video, The Sexual Harassment Case That Changed Everything. The video shares insight about workplace harassment laws, but it is also a powerful story about the courage one young woman took to make a difference in her workplace that ultimately changed the workplace for all of us. So, what would you do if you overheard a coworker making an inappropriate comment about another employee's appearance? What do you think would be the best way to handle it? Please pause the video, take a moment to think about it, and then share your response in the comment section. Now, let's talk about the second kind of harassment: hostile work environment. A hostile work environment isn't just about having a bad boss or a coworker that curses a lot or someone who's annoying you at work. The behavior has to meet specific legal requirements. So, what we're going to do now is look at how behaviors at work cross the line and become illegal harassment. The first condition that has to be met for behavior to be considered as harassment is unwelcome conduct. This means the behavior is not invited, it's not wanted, and it makes someone uncomfortable. If an employee is feeling pressured or disrespected or just overall uncomfortable about comments that are being made, jokes that are being told, or specific actions that make them feel uneasy, that's considered unwelcome conduct. And the person who's doing it doesn't have to intend to cause harm or intend to make the other person who's receiving and observing the behavior uncomfortable. What matters is how it is received, how the person who witnesses the behavior or the conduct or the words that are being spoken, how that person feels. The second condition is conduct that's based on a protected characteristic. So, for behaviors to legally qualify as a hostile work environment, it has to be linked to an employee's race, gender, religion, disability, age, sexual orientation, or another protected characteristic. What we're talking about is when you are being treated unfairly because of who you are, not because you have a disagreement with someone at work, not because you have a conflict, not because there's a personality issue, but you are being singled out and treated differently because of who you are. The third and final condition required to meet the legal standard for a hostile work environment is behavior that has a severe or pervasive impact on work that is being done. And the behavior has to be so bad and so frequent that it negatively affects someone's job. So a single inappropriate comment might not be enough, but constant harassment, ongoing intimidation, or extreme behavior that makes work unbearable, that would satisfy this third and final condition. And this really matters because not every bad work environment is a legal, hostile work environment. But if behavior is unwelcome, if it is discriminatory behavior and it is severe or happens enough to impact someone else's job, it is illegal. If you want to understand what it really means to work in a hostile environment, check out my video, Workplace Mobbing and Retaliation in Medicine. It takes a really close look at the reality of workplace harassment and how toxic group behavior can push employees out and the legal protections that exist. Plus, you'll hear a very powerful story about a woman who stood against the odds to fight for her right to work in a harassment free environment. So check it out. The link is in the description. Let's take a look at some examples of behavior that can make a workplace feel toxic. It's important to remember that what may seem appropriate to you might be perceived as inappropriate and even hostile to someone else. An open magazine left lying on your desk with models in swimsuits could be offensive and become the subject of a complaint. Harassment can be created through personal devices. They can also be the subject of complaints and create liability for employers. Harassment can also show up in verbal and physical forms. For example, name calling, insults, or offensive jokes to others, not to mention yelling, aggressive behaviors, the types of conduct that would intimidate an employee. Harassment can also be demonstrated through physical intimidation, like blocking someone's movement or gestures that cause discomfort. Visual harassment can be anything that is visible to another worker, like offensive posters, cartoons, drawings that are displayed at work, or the act of sending inappropriate messages, or suggestive emails, or text messages. This type of conduct is illegal and it can have serious consequences on an employee's mental and emotional well being, not to mention the impact that it can have in the workplace. So let's take a moment to think about this now. What kind of behaviors do you think could create a hostile work environment? And why do you think it's important for employers to step in early? Pause the video, put a comment below because your thoughts matter and they will help someone else see things from a different perspective. So let's talk about it in the comments. Unlawful harassment doesn't have to be sexual in nature. It can be any type of harassment that is based on a protected characteristic. And these are found under federal law like Title VII, the Age Discrimination in Employment Act, the Americans with Disability Act, and specifically in Illinois under the IHRA. Protections in Illinois include the following: race, color, religion, national origin, ancestry, sex, age 40 years and older, marital status, disability, military status, sexual orientation, gender identity, unfavorable discharge from the military, citizenship, pregnancy, childbirth, or medical or common conditions related to pregnancy or childbirth, arrest record, expunged or sealed conviction. Illinois protections include all gender related issues. This means that discrimination based on gender identity, including transgender status or sexual orientation, is considered sex discrimination under Title VII. And harassment isn't limited to sexual conduct, it also includes offensive comments that are related to someone's gender. Common issues that come up around this topic can involve uniforms, restroom usage, or inappropriate coworker comments or assumptions about gender roles. If you'd like to learn more about harassment prevention and better understand the legal standards required to prove harassment, check out my video. She had 5 pages of evidence, but it wasn't enough. It's a real life case study that clearly shows what's needed and oftentimes what is missing to meet the legal standard for harassment. The term workplace extends far beyond the four walls of an office building. It may include the office, of course, but also off-site areas that are used for work, work-related events, or meetings. Job-related harassment is prohibited even if it occurs away from the work site. For example, harassment would be prohibited during a business trip or at a client's site. A hostile work environment can happen anywhere. There is no off-property exception. Harassment can occur anywhere that an employee represents their organization. Harassment includes conduct that occurs beyond the office if it arises out of the employment relationship. Managers have to watch their behavior after work. When they are at a company function, a holiday party, when they're traveling on business, even when they are online, the same workplace policies apply to any work related situation, even when off site. Hey, are you still watching? If you find this video helpful, please take a moment to like and subscribe. Your support really helps. Thanks. Anyone who comes into the workplace, anyone who you associate with due to your work duties, can create a hostile work environment. Third-party harassers can be an agent of the employer or a non-employee, such as a contractor, a consultant, an intern, or a regular visitor. An employer can also be held liable for harassment by non-employees like customers if the employer knew or should have known of the harassment and then failed to take corrective action quickly, promptly that was needed in order to resolve the issue. Whenever I conduct this training, one of the more common questions that I get is, how do I know if I have crossed the line? And what I tell people is to picture someone you really care about, someone that you respect, someone that you actually want to protect. Either respect them, you want to protect them. Now imagine them going through whatever the situation is that you are thinking about, that has been brought to your attention, or that you have experienced. If it doesn't feel right for them, the person that you want to protect, the person that you respect, then it's not right for anyone. As a manager, you have an additional layer of responsibility. This means if something crosses that line, you have to step up, you have to step in, you have to engage. And exactly how you handle it can depend on what's going on, but it usually means stopping the behavior immediately and notifying human resources. Under Illinois law, an employer can be held strictly liable for the acts of supervisors who engage in harassment. Let's talk a little bit more about this and what it means. Under federal law, supervisors and managers generally aren't held personally liable, meaning employees can't sue supervisors and managers directly. But in Illinois, it's different. Supervisors and managers can be held personally liable under the Illinois Human Rights Act. Plus, any employee can be personally sued under common law for things like battery, false imprisonment, or even intentional emotional distress in certain cases. If that happens, an employee would need to work closely with a lawyer, and their actions will definitely be under close review. And when harassment claims involve someone who is not a supervisor, like a coworker or a customer, the big questions are, did the employer know about it, or should they have known? Did they fail to take immediate steps to stop it? And could they actually do something about it? If the employer steps in quickly and handles the situation appropriately after finding out, they might avoid being held legally responsible for what happened. Managers should always report any harassment situations that are brought to their attention, any complaints to human resources right away. They have to make sure that they take every complaint seriously and let the employee know who they are speaking with that is making the complaint, that retaliation won't be tolerated. Always say that and then check in with the employee later to confirm that things have improved. It's also important for leaders to document clearly what has happened and that the problem hasn't continued. As a supervisor, it's critical to escalate these concerns through the proper channels because the supervisors have a first line of sight. They are the eyes and the ears for the organization. And using that official reporting system that's been created protects both the supervisor and the organization from liability. Never promise to keep something completely confidential when speaking to an employee because you can't guarantee that. One common issue I've seen in managers is when they know something is wrong, but they fail to report it, they fail to address it, they fail to make human resources aware of it. Don't make that mistake. Always escalate and act promptly when issues of harassment are brought to your attention. When harassment claims are successful, employees can receive different types of compensation. They can receive back pay for lost wages, front pay for future income loss, and even money for emotional distress or attorney fees. Under federal law, that is under Title VII, employees can also receive punitive damages, or the person who is bringing the complaint against the employer can be awarded punitive damages. And that is money that is specifically intended to punish an employer who ignored an employee's rights in a very malicious, intentional way. For example, one jury initially awarded a woman $95 million dollars and then later reduced that to $40 million after severe sexual harassment at Aaron's Rents. But keep in mind, under Illinois state law, punitive damages aren't allowed. Under federal law, if harassment doesn't result in a clear job loss or demotion, the employer might avoid liability, but only if they have a strong anti harassment policy that everyone knew about. And if the employee didn't speak up to complain, then they could also avoid the liability. On the other hand, in Illinois, the law is tougher. If a supervisor harasses someone, the company is automatically responsible. There are no exceptions. And that's one of the reasons why it is so important for employers to take reasonable steps to stop discrimination and harassment from happening in the first place. When issues do come up, employers need to act quickly to put a stop to it and to fix any problems that it's caused. Employees should have clear ways to speak up and communicate their concerns. Employers need to investigate every complaint fully, promptly, carefully, and if it's needed, they should discipline or correct the behavior right away. But remember, employers can't fix problems they don't know about, so speaking up is important. If someone feels they've experienced harassment, they should immediately check the company's complaint process and let HR or whoever else is designated know about the issue. The company then has an obligation to quickly start an investigation and handle the situation as fairly and confidentially as possible. It's also important that everyone cooperates during these investigations. Anyone found guilty of harassment, discrimination, or retaliation could face serious consequences, anything from a warning up to losing their job. Also, keep in mind that the person reporting the issue isn't guaranteed to get the exact outcome they want. The company's responsibility is to make sure the investigation is prompt, thorough, and fair, and then make decisions based on the evidence. If employees are involved in consensual workplace relationships, the company might have a policy on that too, like a love contract or requirement to disclose those relationships. So employees should be aware of those policies and make sure that they follow those guidelines. If you hear about, witness, experience harassment, talk to human resources or management immediately and always write down the details. Make sure someone addresses the situation right away and be ready to help with the investigation by providing facts and details. Afterwards, stay involved and make sure that you follow up on the issue until it's fully resolved. Excuses, any excuse, is not a reason not to report a harassment claim or an issue with harassment in the workplace. Things like it didn't happen at work, or she never complained, or it was a one time thing, those types of reasons do not relieve supervisors or employers from liability. Supervisors
They have an obligation to immediately report any complaints of harassment using the method that's been designated by the employer, and they are also obligated to allow the investigation process to play out. No excuses. So, what should you do if you experience or witness harassment at work? Let's talk about the steps you should take. The first step is to document what has happened. Write down the date, time, and location, what happened, how it made you feel, and save any relevant email, messages, or evidence. If you're comfortable, consider confronting the harasser. Describe the behavior that bothers you, why it's a problem, how you feel, and how it affects your environment. Tell the harasser that the harassing conduct must stop and explain how you would prefer the situation be handled. Inform the harasser that if the harassing behavior continues, you will complain to management. The next step is to report what you have seen or experienced to human resources or management. Managers and supervisors are held to a higher standard than non supervisory employees when it comes to harassment prevention. They are required to take immediate action if they witness or become aware of harassment. If you are a coworker who learns about harassment, listen, and if the harassed person is comfortable, suggest that he or she confront the alleged harasser. Offer to practice the confrontation and suggest supportive feedback. Encourage the person to report the harassment to the person or department that the harassment policy designates to receive these types of complaints. And you should also report it yourself. If you are the alleged harasser, that is, you are the person who's being confronted about your own behavior, the first thing to do is to listen. Try not to be defensive. Keep an open mind, even if you disagree. Stop the offending behavior, if possible. Express your willingness to address the situation, and if you cannot stop the behavior, tell your supervisor, speak with management or human resources. It's important to remember that if you are the alleged harasser, you need to maintain a normal working relationship with the person who is accusing you or confronting you about harassment. Don't retaliate against the employee for his complaint or her concerns. Cooperate with them. Tell them the truth in the investigation and don't spread rumors about the situation. Always remember the protect and respect test that we talked about earlier. If the conduct is not appropriate for the person that you want to protect, person that you respect, then it's not appropriate for a coworker either. Retaliation and bullying are another form of harassment, and the behaviors are closely linked together because when an employee is subjected to bullying, it's often triggered by retaliatory actions, which is why these issues are typically linked and addressed together. Retaliation occurs when an employer takes an adverse action or a negative action, really, against an employee for reporting harassment or participating in an investigation. This not only harms the individual employee, but also discourages others from coming forward, ultimately creating a work culture of fear and silence. Examples of retaliation include being demoted or fired after filing a complaint, a demotion, salary reduction, or unfounded and illegitimate disciplinary actions, having work hours cut for speaking up about misconduct, or even termination. It's important to know that the law protects employees from retaliation, and that helps make sure that when employees do have the courage to speak up or to help out in an investigation, that they're not going to be punished for their efforts to promote a safe and respectful work environment. If you want to know more about retaliation at work, check out my video, Workplace Retaliation. It covers the legal case between the University of Texas Southwestern Medical Center versus Nassar and the retaliation efforts that were taken by the employer in that case and what the court decided as a result of the employer's actions.
Now that we've covered key aspects of workplace harassment prevention, it's time to test your knowledge. Click the link in the description to take the official quiz. Let's review what we've learned today. We talked about what workplace harassment is and how it impacts employees. We talked about different types of harassment, including sexual harassment, bullying, and retaliation. We also discussed employer and employee responsibilities, how to report misconduct, and how to protect your rights. We also discussed the concepts of no retaliation and how to create a safe and respectful workplace. Congratulations, you have made it through harassment prevention training for Illinois. By completing this training, you are helping to build a workplace where everyone feels valued and appreciated. Now, don't forget to take the official quiz and subscribe to the HR Insider for more workplace training videos. Like, comment, share, help others stay informed. If you are looking for general workplace harassment prevention training that meets federal compliance requirements for all states, check out my video, Workplace Harassment Prevention Training: How to Stop Bullying, Discrimination, and Retaliation. It covers really important topics and reviews some of the more key aspects of harassment prevention. Thanks for watching. I'll see you in the next video.